problem is if we put into our tax law in do not codify language that a rule that we adopted 22 years ago that we have had all of these years of returns filed by taxpayers that have complied with the requirements of that rule, if we pass a law that says that the DFA director never had the authority to promulgate that rule in the first place, we're going to subject the state to taxpayers being able to amend returns that are currently available to be amended under the statute of limitations to state that this income of this grantor trust was never taxable in the state of Arkansas. And in doing so, we can subject ourselves to at least a $20 million fiscal impact because we would have 3 years that would be available to be subject to an amendment. We entirely agree with the adoption of 671 through 679 for tax years 2020 and following. But we have serious problems if you're going to adopt a law by the General Assembly that says that there was never any authority in the first place to adopt a rule. We've got taxpayers that have filed their returns in reliance upon that, and we cannot take our tax policy in a way that we can look backwards to change the law to provide that the budget is going to be imperiled as a result of that process. So DFA would say that let's either not pass this bill as currently drafted and stop and then pick this back up again and be one of those states that has not yet adopted 671 through 679, or let's strip out this language in here that would cause all of these problems for our budget by saying that DFA never had the capacity to adopt a rule that we did 22 years ago. We clearly had the statutory authority to adopt this rule. And we did so, and we've done so, and there hasn't been a challenge to that rule in the 22 years in court. And where we challenge a rule is when we have done an assessment of tax and the taxpayer states that we didn't have the statutory authority to adopt the rule in the first place. There is a legal process that exists. We should not go through special language or do not codify language in a change that is trying to adopt code sections prospectively to say that everything that has happened in the prior 3 years that would be subject to an amendment would provide that to open up the state's budget to whatever impact might occur as a result of amended returns. I'd be happy to answer any questions.
So here's some comments I have. We have DFA cleanup bills come through routinely. And if you'll remember, we said in here, half of us probably don't understand what's happening, and we completely trust DFA. The bill that you originally filed was not a cleanup bill. The bill that you originally filed, or that you had filed by Representative Gray, actually was retroactive in nature, which I've been told by DFA over and over again isn't possible for bills that I've had passed. My feeling is this: we put so much trust into DFA in regards to what y'all like to call cleanup. And the reality is a lot of that is not cleanup. The reality is a lot of what is passed is actually punitive to taxpayers. It puts them in a lesser position than that of DFA in regards to litigation or whatever may be happening at that time. And I don't think you would disagree with that. I think we had some conversations and even some bills that were passed off the floor yesterday that will negatively impact some of Arkansas taxpayers that we like to call cleanup. What probably bothers me the most about all of this is the way that it was represented by DFA. And I feel in a way DFA's hand was a little bit called on it because you had someone actually research, look at, and see what the impact was going to be on their bill as originally filed in 1911, which then led to people actually paying attention, looking, and having the amended version that we have before us today. So my question is, what was your original intent with House Bill 1911? And would it have not impacted ongoing lawsuits that were in place and done exactly what you're arguing against right now, put DFA in a stronger position in regards to those taxpayers?
Thank you, Mr. Chair. And first, I'd like to extend my appreciation. I appreciate the members of the committee and the members of the General Assembly for the confidence and the deference that is provided for adoption of Internal Revenue Code sections. As our Constitution dictates, we can't have auto conformity in the state of Arkansas. We are required to pass in the sessions that the General Assembly is interested in doing to readopt sections of the Internal Revenue Code that we have previously adopted, or in this circumstance where there are provisions in the Internal Revenue Code that have not yet been adopted. The intent, certainly, as the plain language of the bill, and I have it right here in front of me, is that the 671 through 679, as it was in existence January 1, 2018, would be adopted for the 2019 and following tax years. There was nothing in that bill that stated that anything would be retroactive, that this would be applied to any earlier tax years in 2019. And as I just stated in my comments, we have no problem whatsoever with those structural changes of the bill to make it effective for 2020 and following, to provide the trust practitioners and to the taxpayers to know that we may need to rearrange our process so that this is going to be effective for the return that we file in 21 and not 2020. So and you did mention the technical corrections bill that we did provide as a part of our legislation.
That was not a technical corrections bill. I mean, technical corrections, I understand what those are. That's a changing of a word. That's a misspelling. That is something that does not have true policy change. Technical changes are not policy changes. And so again, I think I'm done in this committee allowing DFA to come testify that these things are called technical changes, because that puts a lot of members at ease when in reality what we're doing is changing policy. Correct?
Well, I certainly don't, Mr. Chair, we're not trying to cause any confusion whatsoever. What we regard as a technical corrections for purposes of an income tax bill that was on the floor yesterday are for code provisions of the Internal Revenue Code that are already in the code and that they have been adopted for a prior year, but however, Congress may have extended the application of that Internal Revenue Code section, or that have made minor changes in that code so that we have conformity with our state law, with our federal law.
I think we've given them, through testimony, that authority to adopt, federal issues.
And I think that's what is a dispute here on this particular bill. There's no sign that we'd ever given the authority for that. I think that's part of what's being discussed right now. And if I'm kind of understanding things right, DFA utilized it when it was beneficial and didn't utilize it when it wasn't beneficial, which is, I mean, the exact opposite of the policies that we should have in place. Again, where I'm at right now is we were all fine in listening to DFA on the initial version of this bill and say that they could have the upper hand. And now we're saying as a committee, well, maybe they shouldn't have that, but neither should the taxpayer. And I don't believe that this gives anyone an upper hand, because again, this is a prospective bill, and there's some legislative intent that's not going to be in the law. That is the big concern, which again I don't believe to exist. But again, is there any other discussion? Would you like me to reach out to the chairman of the House Revenue Tax Committee?